Welcome and thank you for attending. Questions can be asked using the questions pane in the webinar control panel. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to your presenter. You may begin.
Good early afternoon, SHRM, Long Island. This is Henry Shapiro, Jackson Lewis. It is nice to not be able to hear anybody but speak to you all this week or today. It's Friday, September 28th, so at least it's Friday. We walk into Monday, October, fall season upon us. I hope everyone's safe with this wonderful weather we're having. And if anybody else got woken up by their iPhone flood emergency alerts this morning like I did, so that got me up nice and early. Today, I am going to entertain you with the cooperative dialogue requirement in New York City. And just briefly, you might be thinking going into this before you X out and say, oh, I'll save my 20 minutes. Just because you might not have operations in New York City, we're going to get to some slides towards the end where you'll see that this is something that might not be required for your business if you're only on or in Long Island, but it's something that you should consider adopting because it's as frustrating as New York City can be with its aggressive expansion of laws and protections for employees. Two things. One, they're usually well-intentioned, and two, oftentimes New York City's laws and regulations slowly make their way out to the island, about as slowly as traffic on the LIE at 5 o'clock on a Tuesday. So it's something worth paying attention to, and something you might want to adopt internally that will help you'll see, with documentation and possibly preventing future claims. So if any of you have insurance carriers, they'll love it. So as we go on, this will all start for New York City in about 2 weeks. October 15th, employers covered by the New York City Human Rights Law, which is for most purposes employers in New York City with 4 or more employees. Obviously, there are some exceptions to that. The new sexual harassment guidance, which I'm going to kind of cover very quickly at the end, drops it down to an employer even with 1 employee is covered, or employees are covered if they work in an employer with 2 or 3 employees for prevented against sexual harassment. So beginning October 15th, under the New York City Human Rights Law, employers are now obligated to engage in a, quote, cooperative dialogue with persons who may be entitled to reasonable accommodations under the City Human Rights Law. So a lot of times we hear reasonable accommodation, we think disability. You're not wrong, but there's more to it that we're going to get to. And we knew this was coming. This has been around for almost the entirety of the year. As you'll see, this passed back in January, but there was an effective date that pushed it until October 15th. So October 15th is when your New York City operations, if you have any, will slightly change how you handle reasonable accommodations. So the law creates a cause of action for employees to pursue a claim against their employers that refuse or otherwise fail to engage in this cooperative dialogue. And while we're going, and we'll get to this a little bit down the road, you might be thinking cooperative dialogue sounds a lot like an interactive process or a discussion. Interactive process we all know and love because we all deal day in and day out, I'm sure, with the Americans with Disabilities Act. Employees that have disabilities, the New York State Human Rights Law requires an interactive process. That is, the cooperative dialogue is not far off of that. However, it takes the interactive process a couple of steps further, which aren't the worst steps to consider adopting, as I was saying a couple minutes ago. So there could be a cause of action if the employer failed to engage in this cooperative dialogue within a reasonable time, the lovely word reasonable, which is always somewhat subjective, with a person who has requested an accommodation or who the covered entity, the employer, has noticed may require such an accommodation. So it is not enough for you to say, I didn't need to engage in this dialogue because they never said anything to me. If you should have known that they are possibly in need of an accommodation, there's a duty on you. And that's not very different from what we already do now. If we see someone struggling, we will typically try to see if there's a reasonable accommodation that we can provide them, and that's where that interactive process kicks off. So I said before, reasonable accommodations, we typically think disability, at least I think disability most often is what I see come across my desk, but you'll see the other things that it'll cover. Victims of domestic violence, sex offenses, or stalking. This is not unusual for New York City. This is, we all know they just added the safe time requirements to the New York City Earned Sick Time Act. So this is a big driving force of Mayor de Blasio's administration, and also Governor Cuomo's statewide administration. But the domestic violence is going to continue to be protected as it should. Pregnancy, childbirth, or related medical condition, religious needs, which is what we all think of with the religious accommodations, possibly holidays, possibly attire, possibly the time of day an employee may need to leave depending on their faith, and then lastly, disabilities. So what is a cooperative dialogue? And I'll read it just for the sake of doing it, but again, there's a lot of similarities, but again, it goes a little bit further than the interactive process. Cooperative dialogue is defined as a process by which a covered entity, which is the employer, and a person entitled to an accommodation. And the reason why it says person and not employee is because this also applies to public housing and housing discrimination. So there might not always be a situation where it's an employee. But for our purposes, it's an employee entitled to an accommodation, or who may be entitled to an accommodation under the law, engage in good faith in a written or oral dialogue concerning the person's accommodation needs, potential accommodations that may address the person's accommodation needs, including alternatives to a requested accommodation, and the difficulties that such potential accommodations may pose for the covered entity. So just to break that down a little bit further, the good faith will always be subjective, but I think most of you will know, have the open dialogue. Don't walk in there with your employee with your mind set on one thing. Be open-minded. That will usually lead to what the courts consider to be good faith. A written or oral dialogue. If it's an oral dialogue, you should be documenting it anyway. I think we've pounded that into your heads for decades now. Written is always the preferred method. Oral becomes an issue of fact and a he said, she said issue, which can lead you to costly litigation. A writing can stop that. So concerning the person's needs, maybe they need a different kind of chair, maybe they need a different kind of desk, maybe they need a longer break. Who knows what the need could be. Potential accommodations that may address the person's accommodation needs. Understand, similar to the Americans with Disabilities Act and New York State Human Rights Law, you don't need to give them the employee the requested accommodation. It doesn't have to be the best accommodation, but it's got to be one that will allow them to perform the essential functions of their job. So there could be more than one answer. You might be able to give them the best one. You might be able to give them exactly what they want if what they're asking for is reasonable, as a reasonable accommodation, and it is feasible for the company, and it will accomplish and allow the employee to do what they need to do to perform the functions of their job. And the difficulties that such accommodation may pose for the covered entity. So you're all used to this because somebody might come into you and tell you, I work 9 to 5, but I need to only work 9 to noon moving forward, and I'm sure you can figure out a reason why that's a problem unless they're covered by some other FMLA or other type of protection. And you'll be able to say, this is why this is a problem for us. We can't do that, but we could do this, and that's part of the process. After the parties engaged in the dialogue, the law requires the covered entity to provide the person requesting an accommodation a final written determination identifying any accommodation granted or denied. What you need to focus on there are those 3 words in the third line in the middle, final written determination. That's what's different from the interactive process. The interactive process doesn't require a writing. It should internally for everyone on this webinar, because you should always log and document and track with memos to file what goes on in the back and forth with your employee, because ultimately that's going to be your best defense down the road. But here, now, it's required under New York City law as of October 15th, you must provide your employees with a final written determination if they requested an accommodation or you were talking to them about an accommodation that maybe you caught. And it's granted or denied. So if you talk about 5 different potential accommodations, a schedule change, a new piece of hardware, a different, a longer break, something like that, you need to address each one and explain why it was granted and why it was denied, or why it was denied. That's different from the interactive process. We're going to get to why that's not the worst thing for you in the world to do, because it could help you down the road. What if no reasonable accommodation exists? So I get this question often. We can't accommodate them. It's just too difficult. We're unable to do it. We're going to have to let them go and hire somebody else. We can't deal with that. Their position is too demanding. I get it, but I think everybody knows that's not typically how the law works. In this case, if there's under the new New York City law, if there's no reasonable accommodation that would enable the person requesting an accommodation to satisfy the essential requisites of a job or enjoy the right or rights in question, may only be made after the parties have engaged or the covered entity has attempted to engage in a cooperative dialogue. So all that says is you can't come to the conclusion of, no, there's no reasonable accommodation we can make until this cooperative dialogue happens. The same thing goes for the interactive process. Nobody, no counsel would ever tell you you can make that determination that there's no reasonable accommodation without even speaking to them. You got to feel your employee out and understand what he or she may need. That's what the interactive process is all about. When you're making decisions about reasonable accommodations, if you're not conferring with counsel, just internally remember there's other laws that obviously apply. The Americans with Disabilities Act is usually one of the first ones, New York State Human Rights Law, Title VII for religious discrimination issues. Reasonable accommodation, even if you're outside of New York, if you're in New York City, it goes beyond just this cooperative dialogue. If you're outside of New York City, it obviously there's other laws that I'm sure you're all good and familiar with over your years in the profession. The New York City Commission on Human Rights has recently released enforcement guidance on individuals with disabilities. This is not unusual. This is something that the EEOC does rather often. New York City did it now on, I want to say it's a 50 or 60 some odd page report on how employers and others, housing accommodations, but let's focus on employers, should handle individuals with disabilities. The guidance specifically states what's notable. The dialogue could be, this is that cooperative dialogue still. The dialogue may be in person, in writing, by phone, or via electronic means. Again, if it's in person or by phone, you should do what you can to document whenever it's discussed by both sides right after you're done. Do it contemporaneously. Don't wait 2 weeks to say, oh, I'll get to it later. I know we're all busy, but you lose part of what you discussed. You forget important details, and a memo written right after a call versus a memo written 2 weeks after a call is much more strong and believable than one written 2 weeks later, where clearly people's memories, might start to falter somewhat. The Commission's guidance also includes what would be discussing in good faith, which is, again, I said, it's usually a decision of the courts or an adjudicative body, but here they actually give you some examples. So looking at 1, 2, and 3, whether the covered entity has a policy informing employees how to request accommodations based on disability. It's not, some employers I've seen have it, some don't. It's not a bad idea. It's something that could be useful because, again, it's a line of defense when the State Division or the EEOC or a plaintiff's attorney come knocking and saying, you didn't do this. You say, well, we have a policy, and here it is. This is how they requested it. They were given, here's their handbook acknowledgement. They didn't follow the policy. Is it bulletproof? No. Does it help you? Yes. Whether the covered entity responded to the request in a timely manner in light of the urgency and reasonableness of the request. This is another one. It's, the longer you sit on something, the worse it is. Obviously, your employee gets aggravated and agitated. Understanding things happen, and you might get nailed with a harassment investigation that you have to shift all your attention to. But to the extent you can, even if you designate or delegate the duty of speaking with this employee about the potential reasonable accommodation to somebody else, that's fine. Just get it, get something on record and then get it in writing. Whether the covered entity sought to obstruct or delay the cooperative dialogue or in any way intimidate or deter the individual from requesting the accommodation. I don't need to go over that. You all know the pitfalls to intimidation or trying to interfere with the cooperative dialogue or interactive process approach. An indeterminate delay may have the same effect as an outright denial. And the last bullet point, the New York City Commission has said it's a, quote, best practice for covered entities to have a written policy regarding this cooperative dialogue requirement that they disseminate to employees. Is it required? No. Is it a best practice as we would normally tell you? Yes. Council will often tell you if you can put it in a policy, it's not the worst thing in the world, because at least then you have writing, you have something to fall back on. It limits what you could do if it's not in writing, because now you have to follow your written policies and you don't want to be applying it differently across the board, but at least it gives you documentation to fall back on. All right, so as I said to start this whole call off, I understand obviously that many people don't have operations in New York City, so they don't care about the cooperative dialogue. The reason why I think you should is it introduces a process for New York City employers that is worthwhile for non-New York City employers to consider using. Looking at the second bullet point, so we went over how there's a lot of similarities between an interactive process and the cooperative dialogue process. The interactive process is, as you know, the back and forth between the employer, maybe the HR rep, and the employee to discuss what the company can do for the employee to allow the employee to perform the essential functions of his or her job. Here, the cooperative dialogue is basically getting you to the same point. It's something that you should all be familiar with already, because I would bet dollars to donuts everyone's faced this at some point in their HR career. But what I would stress is the difference. The cooperative dialogue process requires you to put things in writing, like that written final determination. What I have taken the approach of doing with some clients who have wanted to get ahead of this is make a checklist for your HR team or whoever, or your management team might be dealing with these accommodations, of what they should want to get out of the cooperative dialogue process. So I listed a couple of bullet points here of just what you want to look for, the reason for the accommodation, dates when, every day something was discussed, what the employee requested, the back and forth, the potential accommodations that are available as far as the company is concerned, the difficulties with those accommodations as far as the company is concerned, if there are any. Maybe it's cost, maybe it's location, maybe it's scheduling, who knows. The difficulties are going to be a fact-sensitive issue. And then the final reasonable accommodation ultimately offered. Or if we don't offer one, why? So the checklist that we just went through and the final written determination give you written documentation. We all know, you've heard from the Chris's and Anna's and Craig's and anybody else that you've listened to speak at any Jackson Lewis event that runs through SHRM is document, document, document. Any attorney will tell you the same thing. The written final determination gives you that documentation that you can then use in a potential future litigation or in a potential administrative charge situation where you can show, no, we did give them the cooperative dialogue. We participated in the interactive process if we're outside of New York City, and we gave a reasonable accommodation, or we offered, or we discussed it. Here's our proof. Listen, is it bulletproof? No. Does it help you substantially? Absolutely. So to wrap up, I figure we'll end, as we're running out of time, with the topic of the day for the last, 6 months or so, sexual harassment. Just to give you all a little bit of an update, I know we have probably been blasting your emails with different guidance and things that we're learning as we learn it. We're still waiting on New York City. The law does go into effect in about 6 months in the city. There are the fact sheet and the poster requirement that have been required as of September 6, 2018 if you have a New York City operation. If you don't worry about that just yet. But we're still waiting on further guidance from the city. We did get the guidance from the state, as most of you know, as far as the model complaint form, the model policy, the model training requirements. The comment period closed on September 12th. We're still waiting the finalized guidance, but time is of the essence, because get ready, training, as you all know, starts October 9th. Unless the finalized guidance pushes it back, starts October 9th. You have to have all your current employees in New York State trained by December 31st on this anti-harassment, sexual harassment training materials. There are no exceptions. So now is the time. It's going to be a crunch. It's going to be a 2.5 month stretch to get everybody trained, and then to have policies and procedures in place to handle those who start post January 1 and get all new hires trained within 30 days. We will keep you updated as we learn more. I thank everybody for joining me and participating in this webinar, and have a wonderful rest of your day and a great weekend. Thank you.